you want to say something, go ahead and talk.
Okay, basically I'm living on the sidewalk of the Supreme Court here because it's been 20 years without due process of law. So original jurisdiction is not really a typical type of case, but when a state passes a law that's unconstitutional and then tries to create a firewall to protect the unconstitutional laws from being struck down in states' rights and sovereign immunity by passing an article to their state constitution 2 years later, they make a fatal error, especially when they quote the article in a case to bring harm on the individual, because that puts it under scrutiny for judicial review. Now, the laws in Utah are called the victims' rights laws, which sound really good, but somebody that commits treason rarely comes up to you in the hamburger outfit with the mask and the black and white striped shirt to say, hey, I'm here to commit treason. They usually dress themselves up as patriots and come up with a good story to make themselves look like the good guys while they commit treason and fool you. So the victims' rights laws sound really good, but let's just analyze them and think for a second about them before we say, yeah, that sounds good. The victim's right to a speedy trial is unconstitutional because, in my case, the police showed up, took evidence, saw that the people were false accusers who didn't want to pay me for my carpentry work. They used their phone to call me a taxi and send me home. But the state decided to prosecute me anyways, maybe because I'm Catholic and it's the state of Utah and they're Mormons. I don't really know how to explain why they would reverse the call on what the police did. The police made the right call, but that's what they did. Now, the judge dated and signed the subpoenas for the day after trial, so the police couldn't be there and no evidence could be there for me to prevail. And so they gave the victim, supposedly, who's a false accuser, a right to a speedy trial to deny my continuance motion, in part to get subpoenas dated and signed for the day of trial, which is not my error, it's the error of the court clerk and the judge. And so they denied my continuance motion, saying the victim has a right to a speedy trial. Now, in my case, I'm saying they're not victims. There is no crime except the crime committed against me, and that they're false accusers. But let's take the case where a crime is committed and the victim is a legitimate victim. Nevertheless, the guy on trial might be the wrong guy. And so since he's not guilty until he's convicted, he's innocent till proven guilty, he's not the perpetrator till after trial, even if their victimhood is legitimate, which is not the case in my case. So you see, the victim's right to a speedy trial is not operative at his trial because he's not the perpetrator, even though the victimhood might be legitimate. So it's not an actual right, it's an anti-right that takes away your rights under the Constitution to raise an adequate defense, like getting a continuance motion so you can get subpoenas dated and signed for the day of trial. Now, the judge knew I was going to win my case. She knew if anybody looked at the record or at the transcripts that they would see that she's not even competent to be a lawyer, let alone a judge. And so they refused to stamp the notice of appeal and mail it to the Supreme Court, which is called certification. The reason it goes from West Valley City straight to the Supreme Court is because the state went so far as to pass an article to its state constitution and then quoted it to bring harm on me by denying my continuance motion. They have placed that law squarely under scrutiny for judicial review, and because the state's a party to the cause by having a vested interest in taking an oath to uphold their state constitution, because it's a state constitutional article rather than just a regular law, they become an interested party, a party to the cause, and they are incompetent to take jurisdiction. Under Article 3 of the Constitution, when a state is a party to the cause, the Supreme Court shall hold original jurisdiction. And the case goes right from West Valley City straight here to the Supreme Court. So they knew that. They knew I was going to win, so they refused to stamp the notice of appeal and mail it to the court, which is called certification. I cannot go into that court clerk's office, beat her to death with the stamp my notice of appeal, put it in the mail, and send it here. Now, I've sent 1,500 emails and 250 14-page faxes to the clowns in Congress. I've dealt with 3 administrations now, Gonzalez, Ashcroft, and Halder, and I even talked to William Souter, the chief clerk of the court, Supreme Court here, on the phone 7 years ago, and other clerks earlier than that, and I've got no play. So I've got no moves left to make. I've tried to contact the media. God bless people like this gentleman Bob here who come by and take video and pictures of me and try to get the message out. So I'll be living on the sidewalk of the Supreme Court, and if they want to turn me into the legal Lazarus and they want to make themselves into the judicially rich old man stepping over my broken body every day until I die, so be it. I'm here, and I'm here until the case is heard. God bless you. God bless America.
Thank you.